Hi, everyone, and welcome back to California Divorce 101. I'm your host, Anna, and this is episode 11 of our series. For those of you new to the podcast, we take the messy, complicated parts of family law and make them simple. Before we begin, here's an important disclaimer. All content was researched, drafted, and produced by the attorneys and supporting team members at Marathi Newfer. The voices and audio delivery are powered by Gen AI. This podcast is for informational purposes only. If you need legal advice tailored to your specific situation, consult a qualified family law attorney. Today, we're talking about spousal support, or alimony if you prefer the old school word. And not to get too intense right off the bat, if you get it wrong, you could be dealing with the consequences for years. So we're breaking down the 8 biggest traps people sometimes fall into and how to avoid them. I'm joined by Kate, who will be sharing insights on the most common mistakes people make with spousal support in California and how to avoid them. Welcome, Kate.
Thanks for having me, Anna. Always glad to be here and talk to you.
Likewise, Kate. So let's start with, why is spousal support here in California so complicated? Isn't there just a formula the judge plugs numbers into?
Not at all. California courts don't just run a formula. They look at a lot of factors: how long you were married, the lifestyle you built during the marriage, each person's earning capacity, health, age, even whether someone can realistically hold a job. Because judges have wide discretion, if you make a mistake early on, it can snowball and cost you far more down the road.
Understood. Well, let's delve right into our first trap, agreeing too quickly. Why is that such a pitfall?
We call this the rushing trap. Divorce is stressful. Emotions run high. Legal bills stack up. The temptation to just sign something and move on is huge. But rushing often means locking yourself into terms that don't protect your long-term interests. Maybe you agree to a payment that's only realistic short-term. Maybe you don't fully grasp the tax impact. Or if you're the one receiving, maybe you sign away the right to future increases or modifications. This agreement shapes your financials for years. You need to understand every part of it before you sign.
Yeah, that makes sense. I can imagine how tempting it can be to move on, but wow, it really pays to be patient. Let's talk about, why does insufficient income documentation trip people up so frequently?
We call this the credibility trap. Courts rely almost entirely on the financial documents you submit under oath. Income, expenses, assets, that's the foundation for spousal support decisions. If your documents are wrong, 2 things happen. The math for support is off, and your credibility with the judge takes a hit. Let's say you exaggerate your income. While this is much less common, you might be stuck paying more than you can sustain. On the other hand, if you hide some portion of your income and the other side proves it, the judge may not trust you going forward. And this can have a huge impact because once credibility is shot, it can affect other areas of your divorce, like custody, property division, everything. And here's the kicker. Down the road, if your financial situation changes, you need those records to prove it. Without them, modifying support becomes so much harder.
So it's not just about the numbers, it's about trust with the court. And another common mistake is skipping a lawyer. A lot of people think, lawyers are expensive, I'll just do this myself. What's the danger there?
This is the penny-wise, pound-foolish trap. People think they're saving money, but it almost always backfires, and they end up paying more to fix their mistakes. Spousal support agreements are full of critical legal language. For example, what happens if the recipient remarries or moves in with someone? Does the court keep jurisdiction to change the order later? Can the order be made non-modifiable? If you don't use the correct legal framework, you could end up paying support far longer than necessary. Or if you are the recipient, you could have much less secure finances for many years. The process is just too complex to DIY.
That's a great point, Kate. Moving on, let's explore some of the less obvious traps, and taxes immediately come to mind. I suspect many listeners believe tax regulations are consistent everywhere. So, what makes California's approach to spousal support taxes so distinctive?
This one's tricky. After the 2017 federal tax law changes, spousal support is no longer deductible for the payer and no longer taxable for the recipient, at least federally. But California didn't follow that change. At the state level, support payments are still deductible for the payer and taxable for the recipient, unless your divorce agreement specifically says the federal rule should apply to state taxes too. If you don't account for that, you can completely miscalculate the real cash flow after taxes.
Goodness, so you could think you're fine and then tax season comes and reality hits. What about looking further down the road into long-term financial planning? What do people often miss there?
We call this the future security trap. Spousal support decisions echo for decades. If you're paying, you need to ask yourself, after support, can I still save enough for retirement? Without the federal deduction, it's a bigger hit. If you're receiving, you have to plan for the end of payments. In California, support often lasts about half the length of the marriage if it's under 10 years. For longer marriages, it might be open-ended, but courts expect the recipient to work towards being self-sufficient. So the recipient needs to use that period strategically: education, job training, re-entering the workforce. Because if you don't, those payments end and you fall off a financial cliff.
So once that spousal support order is set, it's easy to assume it's done. But life rarely stands still. People often forget that life keeps happening. Jobs change, health shifts. Why is it such a problem when those significant life changes aren't addressed legally?
This is the static order risk. Life happens: new jobs, layoffs, health issues, retirement. But unless you file to modify the order, nothing changes legally. If you lose your job and just start paying less, you're racking up arrears, missed payments you legally owe, plus interest. And if the court thinks you deliberately reduced your income to dodge payments, they can base support on your earning capacity, not your actual income.
That's excellent advice. So basically, don't assume life happens is enough. You really need to file official modifications. This leads me to inquire about handshake deals. It seems incredibly common for people to say, "We just agreed via text." What makes this seemingly simple solution such a perilous trap?
Because the court doesn't care about verbal agreements or texts. Only official, signed, and filed court orders count. If your ex decides later they want the full amount plus interest, they'll win, no matter what side deal you had. The only protection is a formal stipulation filed with the court.
That makes perfect sense. Now, let's look at our last trap today. When support payments aren't enforced, why do people wait too long?
Because they hope things will work out. They don't want to rock the boat, or they don't want to deal with their ex. But waiting makes it harder to collect. California gives you strong enforcement tools: wage garnishment, property liens, even contempt proceedings. But they're most effective when you act quickly. Delay, and assets can disappear. Jobs can change, and money becomes harder to trace.
So the theme across all 8 traps is clear. Don't cut corners, don't rely on promises, and rely on an attorney when you are using the court system.
Exactly. Preparation, accuracy, and formal legal channels. That's how you protect your finances and your peace of mind.
That's great advice, Kate. For our listeners, if you're facing spousal support issues, the best step is to speak with an attorney who specializes in California family law. If you like this episode, share it with someone who needs to hear it. And check out more resources from Moradi Nofer at CaliforniaFamilyLawGroup.com. Until next time, stay informed and stay empowered.